Well, good afternoon, everybody. I start by acknowledging that we meet on the land of the Wurundjeri people of the Kulin Nations, the custodians of country, including sea country, for millennia. We pay respects to elders, past, present, and emerging. My name's Margaret Young. I'm a professor here at the Melbourne Law School and director of our Institute for International Law and the Humanities. And we're delighted to welcome Dr Ann-Sophie Levidis from the Australian National University today, who will deliver the seminar with the evocative title Au revoir, Moruroa, Human Rights, Decolonisation and Environmental Justice in the Nuclear Pacific, 1945 to 1972. International law is central to these issues, as is evident from the record of the International Court of Justice. Everyone can read the submissions before the International Court of Justice in contentious and advisory cases which reference the grave impacts of nuclear tests in the Pacific. And this refers to the nuclear test case brought, of course, by Australia and New Zealand against France, delivered in 1974, the request to reopen that case by New Zealand in 1995, and the advisory opinion on nuclear weapons of 1999. Written submissions by Pacific states, including the Solomon Islands and Nauru, document the health and other impacts of nuclear tests in our region. And I guess the salience of their advocacy is more pronounced today at this moment after the advisory opinion on climate obligations has been delivered by the court. So let me introduce our speaker. Ann-Sophie Levidis is an assistant professor at the Australian National University and a research associate at the Weatherhead Research Cluster on Global History at Harvard University. She has doctoral degrees from both Heidelberg University and Sorbonne. Her first book, Restoring Empire Through Law, France at the Tokyo and the Saigon Trials, is forthcoming with Cambridge University Press. Her next book, project, focuses on the transnational grassroots movement against French nuclear testing on the oceanic borderlands. So today we will have a talk for roughly 40 minutes or so, and we'll have some time left over for questions from the audience. Please join me in welcoming Dr Ann-Sophie Levidis.
So thank you so much for the introduction, Margaret, and thank you for coming, and thank you also for the Institute for International Law and Humanities. So today I'm presenting a transoceanic legal history of the nuclear Pacific. And I'm speaking about how protest practices across island and ocean borderland became legally audible. I'll trace how environmentalists, indigenous activists, and grassroots legal actors translated everyday records and action into forms that international law could recognize, setting the stage for later legal and diplomatic confrontation. So this talk is chapter 1 of a larger book on how a transnational grassroots movement in the Pacific shaped international law. Between 1945 and 1972, island, church, students, unions, and legal networks built what I call a legal repertoire. Formats that translated live experience into something courts and ministry can hear. Complaints become evidence, evidence become category. By 1972, that repertoire and the alliances around it created the momentum for the ICJ applications filed in 1973 against France. The same repertoire echoes later in the Rainbow Warrior affair in 1985 and in the activist trials where scientific and medical expertise get braided into claims. Across these episodes, notice the shift in international law vocabulary, from security development to international harm, unequal exposure, and the lexicon of reparation and restitution. Today's chapters show how that shift begins in parish rooms, ship logs, petitions, and maps long before we arrive at the courtroom. So, let me anchor the story in a single object. A sacristy notebook in Papeete on 2 July 1966. It records wind and cloud over, but also the felt world, a metallic taste, a lingering headache. They are Iron State files. They are community records, kept by teachers, pastors, dock workers, nurses. I start here because these small, situated gestures are the first act of legality. What turns a story into something the law can hear is format. An observation becomes a list becomes a log becomes an exhibit. Dates, time, places, symptoms, and a contact name make claims portable across parishes, islands, and eventually ministry. This is where our lens help. 12. Notice who is allowed to speak and under what script. Hibakusha centers lived exposure as knowledge. Crucially, I'm not leaping to diagnosis. I'm showing how noticing, recording, circulating, corroborating, formatting produces audibility. Those entries are the early scaffolding for the legal elements to come later: injury, causation, responsibility, and they travel from the parish room to the courtroom door without losing the world they name. I want to slow down over a single arc. How the program moves from the Sahara to the Polynesian atolls, and what that move does to our categories. In the Sahara, in the early 1960s, combined atmospheric shots at Regan with an underground series in Acre, the desert provided what planners liked: distance, military control, and a bureaucratic perimeter where dissent could be channeled or deferred. But its geography wasn't just neutral space, it was a governance choice, a way to stabilize secrecy, regulate labor, and segment who could see, measure, or contest the work. When the program relocates to Polynesia, much of that administrative DNA travel. Security scripts, restricted zones, procurement chains, and a labor regime that ties livelihoods to their testing economy. Yet, the receiving world is different. Atolls are reef ecologies, not deserts. Livelihoods are ocean-bound, not hinterland-based. Food chains, currents, and weather patterns mean that changes water and wind are felt quickly. Socially, too, Polynesian towns and islands have dense circuits of informations. Churches, docks, radio, when news and worry travel across kin, parish, and union lines. This density produces immediate audibility. A fisherman's ode catch, a nurse symptoms log, a pastor's notebook of headache do not remain private observation. They became shared facts. That is why, in this setting, opposition rarely wear a single label. You see anti-nuclear objections about fallout and fear, but also human rights language about exposure, dignity, and consent, and unmistakably decolonial claims about who governs lands, sea, and risk. The same even is legible across 3 registers at one. And that multiplicity matters because it widens the audience for the complaint. Let me mark 4 waypoints so we keep the chronology tidy. First, the Sahara establishes a template, testing as a colonial infrastructure problem, Second, 1964, the creation of the Center of Expérimentation du Pacifique in Tahiti, the institutional hinge that prefigures the move. Third, 2nd July 1966, the first atmospheric shot in Polynesia called Abdullah Bahram, the day we visited earlier from the Sacristy notebook. And fourth, the late 60s and into the early 70s, bridges take shape across Ireland, Australia, New Zealand, and metropolitan France. Pastors, students, sailors, lawyers who will carry testimony, ship logs, photos, petitions, and medical notes into venues where they can be heard. Since through 12, this relocation is a lesson in who gets to define reasonable risk and through which administrative scripts: security, development, modernization. The margin authors a counter archive that qualifies harm and in place and in time. Through the Hibakusha lens, we center lived exposure, workers, fishers, downwind community, and ask which proof regimes will recognize their knowledge and which will smooth it away at statistical noise. So when I pose a framing question, what does relocation do to bodies, lagoons, and law? The answer is twofold. Materially, it reconfigures pathway of harm through water, wind, food, and work. Institutionally, it amplifies audibility. The move to atoll puts protest in formats: lists, logs, maps, petitions that travel well. By the time we reach the early 1970s, this format and the alliance around them will have produced enough momentum for an international forum to take notice. Keep that hinge in mind. This geography is not just where the story happens, it is how the stories become law. In the Sahara, we see the template that will later be moved to the Pacific. The sequence runs atmospheric at Regan and then underground at Inacre in the early 1960s. What planners value is not only aridity or distance, but a governance settings, military perimeters, layered permits, and control corridors that stabilize secrecy and keep logistics running while keeping publics at arm's length. Around the sites, new roads, depots, and barracks to organize daily life and labor. Some residents are shifted, other funnel into base economies, producing both dependence and displacement. This has consequences for the archive. Technical records are produced in abundance, yields, geology, engineering notes, while live testimony becomes scattered. Parish notes, union minutes, clinic ledgers, press snippets. You end up with asymmetric documentation, a thick scientific file and a thin social one. Yet, even here, repertoires of dissent emerge beyond the fence lines. In mainland France and the Maghreb, through marches, petitions, and editorials that translate technical risk into political accountability. Keep this pattern in view. A security logistics machine that is administratively strong but socially brittle, and an opposition learning to format its claims so they can travel. That grammar, the movement from story to list, to log, to exhibit, is what will later make the Pacific complaints audible in international forums. Before the programs even reaches the Pacific, public opposition is already visible, beyond the Sahara test zone. In Ajaccio, Corsica, 1960, protests against a proposed site enter the French mainland public sphere. Union, students, Catholic left circles. New segments preserved by France 3 show seating decisions contested as question of safety, consent, and democratic control. In Tunis, January 1960, street demonstration connect nuclear testing to decolonization, which coverage in the newspaper Liberation in February. There, anti-nuclear claims fall into a broader argument about sovereignty, extraction, and imperial risk. I foreground these scenes because they prefigure the repertoire that later anchors Pacific claims. The formats matter. A march that yields placards and photographs, a petition with dates, signatures, and addresses, communicate issues by union or student groups, statements by clergy and professional. Each produces portable artifacts that can cross jurisdiction and be recognized by ministry and courts. So when the testing relocates from Sahara, Polynesia, contestation doesn't vanish. It reconfigures across oceans, linking metropole, Maghreb, and the island network. That genealogy helps explain why, by the early 1970s, the movement can speak in a register the law can hear, setting the hinge toward the ICJ feelings and later episodes like Rainbow Warrior. In Polynesia, the testing program arrived in a socially dense and ecologically responsive world. With the creation of the Center of Experimentation in the Pacific in place from 1964, towns are reshaped by payroll, procurements, migration, producing both dependency and disruption. Unlike the Sahara, atolls are reef ecologies. Lagoons, tides, and currents connect bodies to waters and food chain. That means in wind and sea are felt fast, in the catch, in the skin, in lungs, and also in clinic notes. Equally important are the audibility circuits. Church halls, docks, and radio bind communities so that observation don't stay private. A Fisher odd catch becomes a parish announcement. A nurse symptoms is compared at the market. A dock worker photo circulates to youth group and unions later. In these traffic, stories are formatted. Dates, wines, routes, and names become logs, maps, and petitions. Those logs do legal work before any court. They prefigure injury, causation, and responsibility in portable terms. The point is not that atolls are small, it's that they are amplifiers. Their social and ecological density pushes claims into circulation and corroboration quickly. This is why, by the late 60s, the movement materials already look like evidence, ready to travel from parish rooms to ministry and, soon enough, to international forums. I want to shift from places to people who bridge worlds. Picture a pastor teacher with cousins at the dock, a sailor activist who writes for a campus paper, a nurse who keeps a clinic ledger and attends synod, a junior lawyer with a parish uncle. These are brokers. What they do concretely is turn stories into formats that travel. My uncle's sick becomes a dated entry. One Direction becomes a line on a map. Outrage becomes a petition with signature and a contact address. Those are local bridges, edges that shouldn't exist on paper but do in real life, and they collapse social distance. The result network has a small world feel. Most actors are only a few steps apart. Two consequences follow. First, corroboration accelerates. The same claim surfaces as a sermon anecdote, a ship log note, and a student's newsletter's 9. Second, the movement becomes resilient. When a visible hub is harassed or exhausted, information reroutes through other short paths. It doesn't need big budgets. It runs on parish rooms and canoes, radio and mimeograph, solidarity funds for travel and films, and volunteers who translate across languages and social registers. In New Zealand, the teacher Elsie Locke started in 1959-1960, built exactly this repertoire, petitions with addresses, teach-ins, marches, press work, translating moral concern into portable artifacts. That pressure is a straight line to the government decision to take France to the ICJ in 1973 alongside Australia. Now, a necessary counter-bridge, André Gros. André Gros was a professor of law. He served in London's wartime United War Crimes Commission machinery to prepare the Nuremberg trial. Then he became France's High Siege judge. Even with France's absence, Gros questioned Australia in May 1973 and dissented in 1974, pushing back on Article 53 default and on treating public assurances as dispositive. I include him because he personifies the friction at our hinge. Even as Pacific and Australian-Asian network made claim audible, senior jurists resist, forcing the movement to sharpen formats, logs, maps, petition, and doctrine, jurisdiction, interim measures, unilateral declaration. The international ear didn't simply open. It opened against voices like Gros, or that is why the formatting work we have traced matter. When I say counter-archives, I don't mean a shoebox of memory. I mean structure collections that already look like evidence. In parish notebook, thin papete of far, or out on Turia Haurikia, you see wines cloud over unusual dust or rains and who reported them. Clinic and dispensary registers add symptoms and referral with dates and name. School rolls and head teacher minutes quietly record attendance drops and closures of weather or fallout events. Fisher logbooks and market books show catch anomalies and price volume blips tied to place and day. Dog tallies and radio logs contribute time-coded traces, cargo movements, message traffic. Taken together, these are portable formats because they include names, dates, wins, symptoms, contacts, they harm claims. You can cross-check across institution, parish, clinic, school, port, and you can timestamp harm precisely. This is a step from story to list to log and to exhibit. By the time a layer appears, these communities have already done the pre-juridical work, identifying injury, sketching causation, and pointing toward responsibility. At sea, protest becomes paperwork. A yacht or launch leaving harbor produces departures paper, a logbook, and a trail of waypoints fixed by lighthouses, dead reckoning, and star sites. Crews keep radio schedules, coastal post and ham radio club records called time and signal reports. Camera rolls still and film travel home via the next mail boat or newspapers relay. Even when boats skirt exclusion lines, the voyage generates time, place anchors that are hard to ignore. Port stamps, harbor master entries, radio log, and dated image. The strength of this repertoire is institutional legibility. Port authorities, postal clerks and radio operators create third-party records without sharing the movement's politics. That means the resulting bundle, log pages, waypoints, signal, times and photos look like what ministry and courts already trust. In legal terms, protest at sea pins who, when, where, unusual precision, which bolster standards, who is affected or at risk, accusation, what leads even to harm. It's a way of transforming risk-taking into traceable events that can cross jurisdiction and still be heard. Let's make the flotilla concrete and keep it right. We start in 1967 with the Australian Committee Against Atomic Testing yacht called the Trident. The log shows a serious attempt to reach Moruroa, departing 19 March, Auckland 7 April, and then Rarotonga by the 3rd of June. By then, the French had paused atmospheric shots, and a crew illness forced a return. They tried again in September, but a medical emergency ended the voyage. Sydney on 9 October. What matters isn't success or failure, it's paper trail. A Weymouth-long book, port clearances, crew rosters, even health notes, portable artifacts that travel across jurisdiction and can be read by authorities and later courts. Between 1969 and 1970, you see stepping stone voyage out of New Zealand and Australia. For example, the protest traveller Boy Roll clearing from Tauranga towards the zone which keeps the repertoire alive, logs, port stamps, radio traffic. By 1972, a vigor from Greenpeace with David McTaggart sails into the prohibited area of Moruroa. Even the better now 1973 boarding, the 1972 builds a forensic bundle position called Times photographs that ministries and media already recognize. This is a shift from risk-taking to traceable events, and it's directly part of the evidentiary and political momentum that leads to New Zealand and Australia at the ICJ in 1973. In 1972, the capital becomes a relay between harbour and courtroom. In Wellington, marches wind from campuses and parish halls to the French embassy and parliament grounds. The coalition in textbook Small World. Grassroots anti-nuclear grassroots organizers, besides union banners, church delegations, student media, and Maori and Pacific groups who center oceans of sovereignty and community health. What matters for our story is not spectacle, but format. Each action generates portable artifacts, march permits, placards photographed and captions, petition rolls with signature and addresses, press clippings with dates and police attendance figures. Those items circulate through MP's office and ministry and become administratively legible. The street also feeds the sea. Wellington Committee raised funds and kit for crew heading toward Moruroa. Think Friar, later Greenpeace voyage, and coordinate radio relays and press hooks to that logs, position and images will have an audience on arrival. Inside government, the studies from narrow options. Cabinet brief begin to weigh cost of inaction against mounting public record. By year ends the political logic aligned with the evidentiary one. New Zealand prepares to join Australia in taking France to the ICJ. The point is simple. The street paperwork, permits, petition and clipping is what lets a march talk to a ministry and soon to The Hague. 12 is a method that organizes today's chapters. It asks Who authors international norms and from what positionality? Metropole, colony, protectorate, mandate, and how these positions are naturalized in doctrine. It treats the familiar script of security, development, and modernization not as unusual policy settings, but as a juridical devices that allocates risk, voice, and authority. 12 also insists that law doesn't begin in court. It sediments in mundane paperwork, permits, zoning maps, medical referrals, exposure threshold, where categories get mad and exclusion fixed. That's why the parish notebooks, clinic ledgers, ship logs, petitions, and map we have been following matter so much. They are counter-archives that make harm legible in time and space. When these records are formatted as lists, logs, exhibits, they prefigure the very elements doctrine will require. Who is affected, standing, how harm links to event causation, and what repair could look like, remedy. So 12 guides both methods and ethics here, centers the imperial margins as sites of knowledge, treat community records as evidence with provenance, and listen for audibility problem. Not just what is said, but whether the forum is tuned to hear it. That's a bridge between Paris, Rome, and The Hague in 1972, 1973, and it set up the later chapters on Rainbow Warrior, trial experts, and restitution reparation. Hibakusha, literally person affected by the bomb, emerged from Hiroshima and Nagasaki, but quickly becomes a political and epistemic category. It structures access to care, compensation, and public recognition, especially through survivor organizations like Hidankyo, founded in 1956. The core historiography sits at the intersections of testimony and medical knowledge. The classic clinical and epidemiological projects generate powerful data, but they also set proof regimes. What counts as a dose, a threshold, or latency period, and those who can mute local outliners and slow harms. From the 90s onwards, historians and anthropologists widen the lens. We move from a national trauma frame to the global hibakusha. Workers and downweight communities as test sites, atolls, uranium mines, and production complexes. That shift matters for us. It allows Polynesian exposure, logbook, parish notes, fishmark books, clinic register to be read as archives, not anecdotes. Methodologically, I'm borrowing hibakusha not to override island vocabularies, but to insist that exposed communities are knowers. Their formats, date, list, logs, map, and knowledge practice that travel into legal forms. The caution is to resist flattening. We have to keep lagoon ecologies, wind current microgeographies, and language intact in translation. So hibakusha becomes a bridge, not a replacement. Environmental justice gives us a vocabulary for harms that don't present as a single spectacular event, but as accumulated exposure over years, what Rob Nixon called slow violence. In French Polynesia, that accumulation was pattern. Certain archipelagos, certain occupation, certain gendered caregiving roles bore more of the toxic load than others. This isn't a random distribution. It reflects colonial seeding, labor hierarchy, and control information. It helps us make those distributions legible and contestable. Think of fishers, lagoon cleaners, and plantation workers. Their livelihood are not separated separable from the ocean. Sovereignty here isn't an abstract jurisdictional question, but the ability to keep living off reef system without sacrificing one's seaweed or one's grandchildren's health. Once you see the entanglement, the legal question shifts. The harm is not just exceedance of a threshold, but the reproduction of unequal exposure across generations. Practically, this reframing changed what counts as evidence. Logs of winds and rains, school absence list, clinic ledgers, and church synod minutes become time series that show slow toxicity in motion. And it changed who counts as the experts. Pastors who organize sampling chains, nurses who track clusters, and navigators who read weather as a survival skill. Finally, environmental justice pushes from technical assurance, risk is managed to political accountability. Who decides whose body are acceptable collateral? That is why Pacific organization tied environmental justice to decolonization, linking fallout to governance, and why regional forums and churches network frame opposition to French test as a matter of life, land, and self-determination rather than mere safety compliance. This is a register in which petitions, maps, and affidavits begin to travel into court. What does history ask of doctrine? First, treat grassroots archive as structured evidence, not as anecdotes. Ship logs, parish minutes, activist correspondence, and private collections like those maintained by regional interlocutor assemble chains of custody, timestamps, and cross-checked. These archives tracked who collected what, when, and under which winds. They are probative in ways our procedures can accommodate if we let them. Second, map the network that produced the record. Knowledge did not appear from nowhere. Brokers, instigators, fixers, cultural theorists, experimenters converted local witnessing into portable forms. Seeing those roles clarifies reliability. Corroboration is a network effect, not a miracle. Third, adjust standards that mute local peaks, average washout island, general safety threshold, erase harm clusters in places like Turia or among occupational groups. In practice, that means welcoming counter-archive into fact-finding, specifying how logs, maps, and petitions satisfy elements like causation, and calibrating burdens so that the state secrecy isn't rewarded. It also means recognizing that resilience in small world networks helps claims survive harassment or burnout. Evidence will root around repression. Method from social network analysis, long used in sociology, can inform admissibility and weight assignment without collapsing into numerology. If court experts community-generated records to meet courtroom standards, they should reciprocate by tailoring the standards to the ecology of harm and prove that grassroots actors actually confront. This is a takeaway toolkit method. Start your inquiry by inventorying grassroots archive and mapping the network that produced them. Who are the brokers? Who are the short paths? Which ledgers, ship logs, or parish minutes cross-confirm? You are testing not just content but circulation. How did this claim move and harden doctrine Think in terms of audibility. Who can be heard as a speaker? What burden of production is fair once a community can show pattern exposure over time? Where should thresholds sit so they don't erase island scale harms? Adjust interim measures logic to the dynamics of slow violence. If fallout moves with winds and season, relief should anticipate that motion rather than demand impossible proof ex post. Ethics. The archive is alive. Obtain consent for reuse, practice contextual anonymization that protects individuals while preserving structure, and return findings to communities in format they can use. Summarize in local languages, map overlays for fissures, printable ledgers for clinics and copies lodged with church or village repositories. This toolkit travel. It applies in other nuclear and extraction frontiers where states or corporations hoard data on and outsource risk. It also answers a deeper fairness claim. When people have already done the formatting work, listing names, dating wins, drawing maps, law authors then produce procedures that can listen rather than a demand to start over inside the courtroom. Revoir Moruroa is more than an end to atmospheric testing. It names the entry of island world into the making of international law. Networks, church synods, student unions, women associations, navigators, and protest crew converted live harm into a repertoire of lists, logs, maps, and petitions. Environmental justice gave that repertoire a grammar, an equal exposure over time tied to colonial governance and to concrete demands for remedy. That is why by the time states filed in 1973, the crime already sounded like law. The court heard a pre-formatted case. The momentum doesn't end here. The mid-1980s Rainbow Warrior affair dramatized the stakes of maritime dissent and the lengths to which a state would go to mute it, further consolidating transnational solidarities and archives that later fed legal and diplomatic reckoning. The activist trials and scientific controversy that follow show movement actors learning to inhabit expert idioms, epidemiology, dosimetry, hydrology without surrendering the moral core. And the restitution, reparation horizon forces doctrine to keep evolving, not only cessation and monitoring, but recognition, healthcare pathway, and locally governed archives. The broader crime isn't methodological. International law doesn't just adjudicate. It is made upstream in sacristy and community halls, aboard small boats in village clinic. If we can keep those spaces within our evidentiary field, we can hear the Pacific, not as a backdrop to great power policy, but as a world that authors legal changes. Okay, thank you.
Thank you very much, Anne-Sophie. A really evocative message and delivery, and I think that your concentration on form, to me, dovetails beautifully with Gary Simpson's work on the sentimentality of international law, demonstrating how anecdotes become archive in this particularly strong and grave example of nuclear testing. Well, our time is up. I'd like to thank Dr. Levidis for this very thought-provoking speech. I hope she comes back to Melbourne Law School regularly and assists us in our work in international law. Please join me in thanking her.